Picture this. You tell your boss you're expecting a baby, and instead of congratulations, their mood changes. Suddenly, your hours get cut, promotions disappear, or worse, you're let go. That raises the big question many workers ask. Can I legally be fired for being pregnant? The short answer is no. Federal law in the United States makes it illegal to fire someone just because they're pregnant. But the reality is more complicated. While the law is clear, pregnancy discrimination still happens every day, sometimes openly, sometimes hidden behind excuses like restructuring or performance issues. In this video, we'll break down your legal protections as a pregnant worker, explain the key laws like the Pregnancy Discrimination Act, the ADA, the FMLA, and the new Pregnant Workers Fairness Act, and show you what to do if you face discrimination. Part 1. The Pregnancy Discrimination Act, PDA. The strongest protection for pregnant workers comes from the Pregnancy Discrimination Act, PDA, which amended Title VII of the Civil Rights Act of 1964. The PDA makes it illegal for employers with 15 or more employees to discriminate against workers on the basis of pregnancy, childbirth, or related medical conditions. What does that mean in practice? Employers cannot refuse to hire you because you're pregnant or might become pregnant, fire you simply because you told them you're expecting, deny you promotions, training, or work opportunities because of pregnancy, force you to take leave if you're able and willing to work. Under the PDA, pregnancy must be treated the same as any other temporary medical condition. For example, if your employer allows workers with injuries to take light-duty assignments, they must also offer the same to pregnant workers if needed. Discrimination can be obvious, like a manager saying, "We can't afford to keep you on while you're pregnant." But often it's subtle. Pregnant employees may suddenly receive negative performance reviews, be excluded from projects, or face pressure to resign. Courts have consistently ruled that these kinds of actions, if linked to pregnancy, are illegal under the PDA. It's also important to understand that pregnancy-related medical conditions are included. That means complications like gestational diabetes, preeclampsia, or recovery from childbirth are protected. Employers cannot treat you unfairly because of those conditions. The EECC, which enforces Title VII and the PDA, regularly brings lawsuits against companies that violate these rules. For example, retail and restaurant chains have faced lawsuits for firing workers shortly after learning of their pregnancies. Many of those cases end in settlements with back pay, reinstatement, and policy changes. The bottom line, under the PDA, pregnancy is not a valid reason for firing someone. If your employer treats you differently simply because you're pregnant, that's discrimination. And it's against federal law. Part 2. The ADA and the Pregnant Workers Fairness Act, PWFA. While the Pregnancy Discrimination Act, PDA, makes it illegal to fire someone just because they're pregnant, it doesn't specifically require employers to provide accommodations. That's where the Americans with Disabilities Act, ADA, and the Pregnant Workers Fairness Act, PWFA, step in. The ADA applies when a pregnancy leads to related medical conditions that qualify as disabilities. Conditions like gestational diabetes, preeclampsia, or severe morning sickness may require adjustments at work. Under the ADA, employers must provide reasonable accommodations, things like modified schedules, extra breaks, or temporary reassignment, unless it creates an undue hardship for the business. Firing someone instead of accommodating them would violate the ADA. But even with the ADA, many pregnant workers fell through the cracks. That's why Congress passed the Pregnant Workers Fairness Act, PWFA, which took effect in June 2023. This law directly requires employers with 15 or more employees to provide reasonable accommodations for known limitations related to pregnancy, childbirth, or related medical conditions. Examples of accommodations under the PWFA include allowing a pregnant worker to sit instead of stand for long shifts, providing closer parking, modifying lifting requirements temporarily, offering extra bathroom breaks, allowing time off to recover from childbirth complications. Most importantly, the PWFA makes it clear that employers cannot simply push a pregnant worker onto unpaid leave if a reasonable accommodation would allow her to keep working. This closes a gap that many employers previously exploited. The Equal Employment Opportunity Commission, EEOC, enforces the PWFA, just like it does with Title VII and the ADA. If an employer refuses to provide accommodations, retaliates, or fires a worker for requesting them, the employee can file a charge with the EECC. These protections are a big shift. Before the PWFA, many pregnant workers had to prove their condition was a disability under the ADA to get accommodations. Now, pregnancy itself, along with related medical conditions, creates a clear right to request adjustments at work. The message of these laws is clear. Pregnancy should never cost you your job. Employers must work with you in good faith to find solutions, not punish you for being pregnant. Part 3, the Family and Medical Leave Act, FMLA, and job protection. Another key protection for pregnant workers is the Family and Medical Leave Act, FMLA, a federal law that guarantees eligible employees up to 12 weeks of unpaid, job-protected leave each year for certain family and medical reasons, including pregnancy, childbirth, and caring for a newborn. Here's how it works. If you qualify, you can take time off during pregnancy, for example, if you need bed rest or prenatal care, or after childbirth to recover and bond with your baby. While the leave is unpaid, your employer must hold your job or offer an equivalent role with the same pay and benefits when you return. To qualify for FMLA, you need to meet 3 conditions. 1. You must work for an employer with 50 or more employees within a 75-mile radius. 2. You must have worked for that employer for at least 12 months, not necessarily consecutively. 3. You must have logged at least 1,250 hours in the past 12 months. If you meet those requirements, firing you for taking FML leave is illegal. Employers also cannot retaliate against you for requesting or using leave. For example, they can't demote you, cut your hours, or reassign you to a less favorable job simply because you took time off to have a baby. Unfortunately, some employers still try to find ways around the law. They might claim the job was eliminated while you were on leave, or pressure you to return early. Courts and the Department of Labor have made it clear. If the job truly would have been eliminated regardless of your leave, say due to a company-wide layoff, then termination may be legal. But if the timing suggests the leave was the real reason, that's retaliation and a violation of the FMLA. It's also important to know that many states go beyond the federal FMLA. States like California, New York, New Jersey, and Washington offer paid family leave programs, meaning you can receive partial wage replacement while on leave. These programs provide stronger protections and often cover more workers than the federal law. The bottom line, the FMLA gives pregnant workers the right to step away from work temporarily without fear of losing their job. If your employer tries to fire you for taking maternity leave, that's not just unfair. It's against the law. Part 4, real-world examples and how pregnancy discrimination still happens. Even with strong federal and state laws, pregnancy discrimination is still common in the U.S. In fact, the Equal Employment Opportunity Commission, EEOC, receives thousands of pregnancy-related complaints every year. Many employers still try to sidestep the law, often by hiding their true motives behind vague explanations. For example, a retail worker might tell her boss she's expecting, and within weeks, she's suddenly written up for poor performance, despite years of good reviews. Or a waitress might request lighter duties because of pregnancy complications, only to be told, "We need someone who can handle the full workload," and then fired. These situations happen more often than many people realize. One high-profile case involved a national restaurant chain that fired several employees after they announced pregnancies. The EEOC sued, and the company paid hundreds of thousands of dollars in settlements, while also agreeing to revise its training policies. Another case involved a package delivery driver with pregnancy-related lifting restrictions. Instead of offering light duty, something the company regularly gave to injured male workers, the employer forced her onto unpaid leave. Courts found this violated the Pregnancy Discrimination Act because the company failed to treat her the same as other workers with temporary conditions. Subtle discrimination is also widespread. Pregnant workers might be quietly excluded from meetings, skipped over for promotions, or pressured to step back from leadership tracks. Some are told outright that their commitment will be questioned once the baby arrives. Even if the employer doesn't fire them, this type of unequal treatment can still violate the law. It's worth noting that discrimination isn't limited to pregnancy itself. It also includes childbirth and related medical conditions. Workers recovering from complications like C-sections or postpartum depression are also protected. Employers who fire or demote women for needing recovery time risk violating both the PDA and the FMLA. The persistence of these cases shows why laws like the Pregnant Workers Fairness Act, PWFA, were necessary. Too many employers still assume pregnancy makes a worker less capable or less valuable. But courts have consistently ruled those assumptions are stereotypes, not legitimate reasons for employment decisions. In short, while the law is clear that you can't be fired for being pregnant, discrimination continues in practice, sometimes openly, sometimes hidden behind neutral excuses. That's why it's so important for workers to know their rights and challenge unfair treatment. Part 5. What pregnant workers should do if they face discrimination. If you're pregnant and suspect you're being discriminated against at work, knowing your rights is the first step, but taking action is what truly protects you. Here's what to do. 1. Document everything. Keep a written record of incidents, dates, times, and what was said or done. Save emails, texts, performance reviews, and schedules that show sudden changes after announcing your pregnancy. If your hours were cut or you were excluded from opportunities, that timeline can help prove discrimination. 2. Review company policies. Look at your employee handbook to see how your employer handles leave, accommodations, or performance reviews. If they treat pregnancy differently than other medical conditions, that could be evidence of a violation under the Pregnancy Discrimination Act or the PWWFA. 3. Speak up internally. Sometimes discrimination is based on ignorance rather than intent. Talking to HR or a supervisor might resolve the issue, especially now that the PWWFA requires employers to consider reasonable accommodations. But make sure you put your concerns in writing so there's a clear record. 4. File a charge if needed. If internal reporting doesn't work, you can file a complaint with the EEOC within 180 days of the discrimination, sometimes 300 days, if state law applies. The EEOC investigates claims under Title VII, the ADA, the PDA, and the PWWFA. They may attempt mediation, settlement, or, in some cases, file a lawsuit on your behalf. 5. Consider legal advice. Employment lawyers who specialize in discrimination often work on contingency, meaning you don't pay unless you win. They can help you navigate the process, especially if you want to sue after receiving a right to sue letter from the EEOC. 6. Know what remedies are possible. Victims of pregnancy discrimination can recover back pay, reinstatement, compensatory damages for emotional distress, and, in some cases, punitive damages if the employer acted with malice. Courts can also order employers to change their policies so other workers don't face the same mistreatment. Real-life cases show this works. For example, a pregnant retail employee fired after requesting lighter duty won a settlement that included back pay and mandatory training for her employer's managers. These victories prove the law has teeth. The most important thing, don't stay silent. Too often pregnant workers blame themselves or quietly resign. But the law is on your side. By speaking up, you protect not just your own job, but also the rights of future mothers in the workplace. So, can you be fired for being pregnant? The law is clear. No. Under the Pregnancy Discrimination Act, the ADA, the FMLA, and now the Pregnant Workers Fairness Act, it's illegal for employers to fire or mistreat someone just because they're expecting. Pregnancy must be treated like any other temporary medical condition, and reasonable accommodations must be provided when needed. But while the law protects you, discrimination still happens. That's why it's so important to document your experiences, know your rights, and act quickly if something feels wrong. Filing a complaint with the EEC or speaking with an attorney can make the difference between losing your job unfairly and holding your employer accountable. If this video helped you understand your rights, hit like, share it with a coworker or friend, and subscribe for more plain English guides to workplace law. And tell me in the comments, have you or someone you know ever faced pregnancy discrimination at work?